is the principal legislation in Victoria that applies to common law claims for damages for personal injury cases other than workplace injuries or transport accidents. Our guest today is personal injury lawyer Henry Carus, and he is going to explain the Wrongs Act and the recent changes to this legislation. So Henry, thank you for being here today.
My pleasure, Cindy.
Well, Henry, what is the Wrongs Act?
Well, look, it's a quite extensive piece of legislation that covers a number of areas of the law, but for our purposes in personal injury, I'd like to focus on how it applies to two areas of the law that we see quite regularly, and that is accidents in a public space and medical negligence. And in those areas, the Wrongs Act provides a number of provisions that govern what is the responsibility of someone who has, let's say, a public place, a commercial place. It also provides responsibilities for health providers, health professionals. It provides details about what kind of compensation can be obtained in that area of the law. It provides processes that are required in order to get access to that compensation. So it's a pretty comprehensive piece of legislation when it comes to accidents in a public space or claims against healthcare professionals.
And Henry, what are the recent changes and why were they needed?
The legislation was significantly changed in 2003 in Victoria to limit and restrict the scope of both access to compensation and the amount of compensation that can be achieved by such claims, either in a public place or by a healthcare professional. And in doing so, there was quite a bit of concern that the legislation had gone too far in restricting access to compensation, that there were areas of the law now barred from, for compensation which should not have been barred. And it took about 14 years of agitation, well, 13 years of agitation, to finally get it to be changed. And so the areas that needed to be changed were ones that dealt with who had a significant injury, who could get access to compensation, what's the value for compensation for pain and suffering, and what compensation could be received for economic loss, wages, and finally whether you can get compensation for providing services to other people who are dependent on you. Those are the areas that were being addressed.
And how has this legislation been fixed?
Parts of it have been changed, which are really helpful. There are two specific areas that were very painful to people, and that is we have a lot of people who suffer a back injury, and there was a reference in the legislation that you needed to get an assessment using a book called the AMA Guides of more than 5% in order to get access to compensation. The vast majority of people with a back injury only got to 5%. So in not getting to more than 5%, which is 6%, they were being excluded. Yet those kind of people, if they're injured in work cover claim or injured in TAC, would get compensation and can get up to $200,000 or more. So here we have this whole body of people injured in a public space or injured by healthcare professionals who are being shut down from compensation completely. The same concept was being applied to psychiatric injuries, so both have now been somewhat opened, and so that therefore people who have either a back injury or a psychiatric injury are going to be allowed compensation on a much fairer basis. That's one of the changes that occurred. Another change that occurred, which was quite significant, was that the cap or the limit of how much pain and suffering compensation you could receive in these areas of the law, public liability, medical negligence, was much less than what was made available for people injured at work or by a motor vehicle. And the legislation change that just occurred this year has evened the playing field. The compensation is now equal across all of those areas of the law, which is much fairer to people who are injured in a public space or by medical negligence. The other two areas that I mentioned, economic loss, again had the same kind of penalties and restrictions, which you don't see in other areas of law, and that's been fixed. And then many people injured in a public liability accident or medical negligence are actually carers for other people, either children or other people who are dependent on them. And you can get the value of that service as compensation. You could have gotten it before. The changes in 2003 took it away or seemed to take it away. The recent amendments have given it back, and which has been really quite helpful to those people.
Well, Henry, you mentioned a number of individuals that will be helped, but can you kind of summarize who will be helped by this?
You're getting, in my opinion, a lot of people who suffer a fall and injure their back, and that's their principal injury. they will be tremendously helped by this legislation. You'll also be helped by people who are high earners, who are earning a considerable amount of income at the time of their accident. The previous legislation would limit how much compensation they could receive. That's been taken away. You're also helping people who are mothers or other carers for young children. They're going to get compensation for the value of services they will now need because they can't care for their children any longer. So those are the three areas that I see primarily will be assisted by these changes.
And what compensation is now available?
Well, you're able to get pain and suffering up to $577,000, which is the same across the other areas of law, and that's dramatically quite beneficial to people. You can get value for services for as long as you're going to be responsible for the children, and you get the economic loss up to the same limits as before. So the compensation picture now across all areas of the law are similar, which allows a bit of fairness in our community.
Very good. A lot of great information. Henry, thank you so much for being with us today.
My pleasure, Cindy.
Until next time, this is Cindy Speaker for Victoria Law TV.